And start. Good morning, all. I'm sorry for my tardiness. I had too many meetings today. This is the Incarceration Prevention and Reduction Task Force Legal and Justice Systems Committee. It is October 12th, 2021 at 11:31. I'm going to start with the land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths and at any and all public events. Right, I'm called to order. And the first item on the agenda, we've kind of hashed out and talked to death, but I want direction from the committee on where we want to go with domestic violence. Do we want to seek out individuals at Western? Do we want to attempt to make some changes to see if we can get the insurance companies to recognize that as a needed treatment? We need behavioral health people for all different areas. So we want to try to create incentives to get more in our area. So I'm looking for direction from the members of this task force.
Chief Kingsley, do you have anything in particular you'd like to add? Because you're on the sort of front end of seeing cases.
Absolutely, and as I was looking through the list of the next steps, you know, what I'm not seeing, and it's just a thought, you know, is that in law enforcement, and maybe the undersheriff could help me out, is that I know certain departments have behavioral health officers, but have we intentionally taken a look at within our ranks of officers or team members or deputies that might have specific an educational background in social services and different humanities to potentially recruit more officers that might have knowledge in this. Or actually, another step would be, as we look to hire and recruit officers, 10, 15 years ago, police agencies focused more on people that had a criminal justice background. And I think there's a paradigm shift with the need of recruiting new officers to look more of a sociology, psychology, social work type of background. So that's one thing that I would add with regard to the personnel that we have on board right now and for future team members.
That makes very good sense to me, to strengthen the education of the officers. You know, I recall Chief Dahl talking about wanting to have more behavioral health police officers in the future. That was one of his goals because he began to see the value of this training. But so I think that's a very good suggestion, but also it goes back to the training programs of the officers in officer training, which is an area where the chiefs have more influence than people from behavioral health do. Like, you have an opportunity as a chief to give feedback to the training programs to make these kinds of changes, which I think they're probably starting to do anyway, but I don't really know that for a fact.
Well, certainly, there's some state mandated training that we have around crisis intervention, but the state mandated training is really an initial 8-hour training and then a update for crisis intervention one time a year. There are many departments that have officers with the 40-hour certification course in crisis intervention. My goal here in the city of Blaine is to get all of our officers certified with that 40-hour course, but even with a smaller department, that takes some time to do. You have to have officers off the street to attend that training. So it's a goal that's achievable, but it does take some time. So with any agency, upgrading that training, which takes hours, and then you have to be able to pay for that training as well, oftentimes. And even if the training is free, there's other costs that's associated with that. But that's certainly something that I'm sure the other departments around the area have been looking into and have been doing.
So much of the reports and feedback that we've gotten from people who have testified to our committees is related to funding. So to me, that's one of the things that stands out the most is it seems like we don't have money to do the things that we need to do. So that's a crucial piece of the puzzle.
Thank you, Arlene and Chief Tanksley. I believe I saw Under Sheriff Chadwick's hand up and then Darlene Peterson.
Well, good morning. Well, I guess it still is morning. I just echo what Chief Tanksley said. Again, all our deputies have the initial crisis intervention training, and then we have 2 specially designated behavioral health deputies, and we provide them even more. They receive the 40-hour CIT course, but we also look for other training that may be beneficial to them. I know we've sent some of our detectives to trauma-informed interview, and we've also had domestic violence specialists within the detective bureau, as well as patrol, that have some additional training, and it's more social service related, how to conduct those interviews with people that have been involved, whether it's domestic violence or behavioral health issues, how to identify and how to speak with those folks and try and get them the resources and help that they need. But like Chief Tanksley said, it's difficult to get everybody that type of training, especially when it's a week-long course, because again, we have the core functions of providing, responding to 911, and but we work very hard to provide as much training, and we've really looked at trying to host as much training here locally, which cuts down on those training costs and doesn't take our deputies and our officers out of the area. And we also put a lot of investment in our in-house instructors. We send them away to training, ideally a train the trainer course, where they can come back to Whatcom County and provide that training for our deputies. And we regularly offer that to other jurisdictions within Whatcom County to make sure that they all have as much training as we can provide.
I appreciate what you said, because this is some of the information that we and the public don't have. And I think that what you just said connects to another topic we're going to be talking about today, which is the PR program for what the task force has been doing and intends to do, because the public would want to know what kind of training the officers are getting and that they are getting it. So, to me, it's really important what you just said.
Well, unfortunately, in law enforcement, we do a very good job of training. We don't always do the best job on conveying that message to the public and letting them know what we're doing. But we're trying to get better at that.
Thank you. Darlene, I believe you were next, and then Stephen.
I was just going to mention that one of the ways to fund domestic violence offender treatment really involves getting the community, city, county, small city councils involved. I know for Bellingham and for Whatcom County, Our city council and the county council are the ones who have passed the ability for us to be able to put money into offender treatment. One of the things that I see as something that I don't know how to go about it, but especially now that Don Stahl is leaving treatment, we're really short on providers. And I know at one time there was some reaching out to different counselors or different treatment firms, letting them know that there was some funding available. But I don't know if Amy Roberts would have any ideas or anyone else would. I wish that I was coming with a solution rather than just a question, but the problem is we're desperate for treatment providers. And we have, since the legislation was passed and Amy Roberts has been involved, I think domestic violence has brought treatment has brought its standards up significantly and made them, put them across the board and help to make domestic violence treatment more effective. But it can't be effective if no one is out there doing it. And so in my mind, that's probably the number one problem that needs to be addressed. And it's very hard because there's not a lot of money in providing that kind of treatment. And courts certainly can't mandate people to provide it to people who are indigent. And that's where getting money from the councils has been helpful. But I don't know what the answer is for trying to encourage participation in providing that treatment.
Thank you, Darlene. I concur with all of your statements. I am very concerned with Don Stahl leaving and how that's going to affect the treatment. I also know that it was brought up on the small cities for civil funding, also for civil attorneys and legal aid, because there isn't currently any civil assistance for those involved in a bad domestic violence situation to have attorneys represent them in child custody issues or divorce proceedings. I'm gonna go to Stephen and then Bruce. It looks like you have a hand up too, so I don't know which one wants to go first on that, if you're just commenting on Darlene's, but I'll let Stephen first because he was sitting there waiting longer.
Okay, thanks, Raylene. Sorry, Bruce. I'm on the same track as Darlene. I certainly think it would be beneficial to have the kind of law enforcement training strength that Chief Tanksley and Under Sheriff Chadwick suggested, but I really think that the crux of this is in the treatment piece, not the skilled first intervention kind of approach. So my sense is that a letter to the insurers, I start with the fact that it appears that a lot of judicial officers and at least some defendants are open either at a point of diversion or a point of disposition to getting treatment. So access to treatment is really the issue. And access to effective treatment is the sub issue there. So you mentioned the possibility of pressure on the insurers to cover this for Medicaid recipients. I think that's that can't hurt, and that would get at the crux, one of the cruxes of the issue, it seems to me. I don't know how effective that would be, and I don't know how prolonged an effort that would require, but it certainly is something that the task force could weigh in on. It's not clear to me from what Amy Roberts has presented to us that there's a lot of actual research on the effectiveness of even the new standards. I know she said that across the country, some treatment providers thought that we had done a good job setting that up, but I don't know if there's data, and I'll just remind us all that our ordinance requires us to adopt evidence-based stuff. So to me, that's not an obstacle, that's an opportunity, because I also recall Dr. Alexis Harris talking about the possibility of DOJ, for instance, federal grant funding for demonstration projects. And this may be a way to try to both get some funding for treatment and develop some evidence for effectiveness of treatment. And I would suggest that would be one question that the group that's going to talk with her soon explore with her is the possibility of funding opportunities to demonstrate effectiveness in domestic violence treatment.
Thank you, Stephen. Bruce?
I don't want to repeat what the last three speakers have said, except just to say that I agree. But just to give you an update, and that is that Jake and I have been in communication with Amy Roberts, and she's aware of our situation. With Don retiring, the only provider that we have a contract with right now is with Andrea Carey Grant and Relationship Resources for Domestic Violence Treatment. And we've been in touch. Amy put us in touch with an agency in Eastern Washington that provides, and it's approved by Amy, the remote services. And so we've been working with her. She's got a copy of the implementation guide. She knows what the contract looks like. We forwarded one of the other contracts to her, so she knows what's involved there. And so we're following that angle. But I think that I think there are bigger issues here with our lack of treatment providers. We've got one, and Jake may be able to shed some more light on this one. There's a provider in Linden that's, I believe, giving up the DV portion of her practice. We have the Lummi Nation, but they they serve their clients, and so we don't have them as a resource in terms of the funding to pay for it. Our clients do take it, who qualify for their program, are able to get in and take advantage of that. But the issue of not having treatment communities is much bigger. We're just trying to sort of put a Band-Aid on this thing and find another agency. Jake, I don't want to speak for Jake, but Jake has talked to Andrea about her capacity and being able to take on Don's and that kind of thing. So we're working that from this angle, but I sort of feel like really what we're doing is a Band-Aid to what this bigger issue is. And I don't know, Jake, if you want to add anything there, or if that kind of covers it, but.
Yeah, thank you. I have, Andrea did express she has the ability to expand. So we're working with her on that with her current referrals that are leaving Don Stahl. And then with the agency over on the east side, they're also looking to expand. They have 4 branches over there. They all provide Spanish speaking sessions as well. And they're looking to come this way. So again, we've sent everything over to them. They're in reviewing it, and we'll probably hopefully have something set up this week or next week to follow up with that. So.
Thank you, Jake and Bruce. I appreciate that. I do have a question. Is there other mental health, behavioral health treatment providers in the area that we could reach out to see what they would need to entice them to get certified for domestic violence treatment?
I mean, there's lots of providers out there. I don't know how that would be approached. The ideal for me would be, honestly, is one of the alcohol drug providers providing dual services. I think that'd be a great way to keep costs down, share a facility. And, many of our clients have both of those requirements, so that, if they could go to one place and have, both treatments available, that would be an ideal situation. So.
Arlene, you're on the board of the North Sound ASO. Isn't this a discussion in the 5 counties that oversees, and what's happening there in terms of capacity?
That's true, because they're just dispersing funding, and also they apply for the funding also when it becomes available from the state or other organizations. So it's something that I think I could bring to the behavioral health, North Sound Behavioral Health Board, because this is just what we're really talking about is crumbs. What we have here is crumbs, and it is not sufficient. It's just not. And thinking about the idea that there's one provider in a county of 250,000 people, is, to me, strange at the very least. Knowing how much domestic abuse goes on.
Thank you, Arlene. I would like to ask Bruce and Jake if you guys could reach out to the drug and alcohol treatment providers and see what they would want to entice them to get that. So we might be able to have that dual treatment and bring that. And Arlene, if you can research and see what else you think we can do to entice more treatment providers in the area. And then I'm going to put Maya on the spot because I'm hoping that she can give me more information on juveniles. Because of just in my history, I know that it's a cyclic program with families to repeat offenses. Is there a way that when there's a juvenile involved in domestic violence and they end up in the criminal justice system, that there could be family treatment that might stop this before it goes into the future? Or am I way off base?
Well, I mean, Bruce, there used to be it starts with an F, and family, oh boy, I'm sorry, it's been a while since I practiced in juvenile court, but there used to be a juvie probation officer who did the family counseling, but they can't mandate the parental involvement, so it's got to be a cooperative situation, a family that wants to participate. I don't know if Bruce or maybe, I don't know if, and there's any, Jake, maybe you remember, it's neither.
I'm not myself remembering, but
it was it was an acronym that started with an F, and it was like for family counseling, but I don't know that it was hugely successful because of the whole voluntary compliance aspect.
Mm.
You could have a kid that was willing to and parents who wouldn't. Go ahead. Sorry. Go ahead, Bruce.
oh, I have a comment independent of your comment. So go ahead and finish what you've got going and I'll.
No, I'm sorry. I don't know that I have any more information on that front.
I wanted to comment, Raylene, on your request that we speak with the treatment agencies who we have working relationships with all of them. But in terms of just a sort of a protocol thing, I need to check with my judges and make sure that they think that's an appropriate role for the court to play. And if they give us the go ahead, I don't have any problem with that. And but I do want to, before I step too far out on that one, I think that I need to make sure that they are in agreement that that's an appropriate role for the court, and maybe it might be better placed with another part of people who are on this committee, possibly. I don't know, but we'll get an answer to that. And if they give us the go ahead, I don't have any problem doing that. In fact, that I don't have any problem doing that at all. And because I know, as does Jake, as does our staff, that domestic violence isn't just a generic community health issue. There are specific victims to each one of these offenders. And whether we have the best treatment model or not, it's the best that we have. And what's out there with the standards that Amy has, this is our best bet for not just creating a healthier community, but being able to help take care of those victims and their health and safety as well. And of course, we all know there's usually more than one victim as the process rolls through. But we're willing to do it, but I do need to get the go ahead from the judges to make sure that this is an appropriate role for the court to be playing.
Thank you, Bruce. Stephen and then Maya.
Thanks. First, quickly, I think Bruce was addressing his last comment to my concerns about what we knew about effectiveness of the new standards. And I agree completely. I was not trying to argue for not utilizing those standards. I was, as I said, trying to see an opportunity there to demonstrate effectiveness as we use them. The question I raised my hand about was back to approaching Medicaid insurers, the managed care plans. And I wanted to ask Perry whether he thought that had any potential of success. I know there's probably sort of a template of a letter like that based on the Crisis Stabilization Center. And so an assessment of potential there and whether or not you might be able to help us craft an appeal like that to the managed care plans, Perry.
Thanks, Stephen. From my limited knowledge in regard to this, we're struggling right now in terms of getting managed care organizations to essentially fund the Crisis Stabilization Center at a level that's necessary to provide the 24/7 nursing and, and et cetera. And so what my experience has been thus far in terms of that communication is they are very hesitant to fund anything that is not mandated within the contract from the healthcare authority. Doesn't mean we couldn't approach that and obviously build a case for it, because I think there is certainly a case for it in regards to what we're seeing from their perspective of upfront cost or cost without addressing that particular piece. And so I think that's probably all the viable information that I have there. But I'm also obviously involved in the county coordinators meeting with the ASO and some of those pieces. And as Arlene had been speaking to, I can certainly bring that topic up from there as well to find out what other counties are doing in this obviously very significant and common occurrence within that setting. So I'm more than happy to do that piece as well.
Would it be more appropriate to think of targeting any pressure on the healthcare authority first rather than the plans?
I think so.
Yes.
I believe so. Yeah. And there are meetings that avail that, and so I will begin to, and I will speak with Jackie in this regard that, that we attend, that they often will reach out, provider meetings that the HCA attends, that we can, they ask for agenda items. And so we can begin to bring this topic up and just report back, and more than happy to do that.
Thank you, Perry. And Stephen, go ahead, Maya.
It's called functional family therapy. So it's FFT was what it was referred to when I was in juvenile court. But as I understand it, they don't have an in-house provider any longer. So I guess they don't have a probation officer who is trained to do that. So they don't apparently do it through juvenile court any longer. But DCYF has that as an offering, I think, for families that are involved with DCYF. So it's still maybe a viable treatment plan, but not used through, or at least not ordered through the juvenile criminal justice system, but maybe through family court or something like that.
Might not be something we want to let drop off the radar, or at least look into if there is evidence on how well it did work. But I think it's going to be difficult, as you said before, if we have families, children that are wanting to participate, but not family mandate in there. I don't know how successful it would be. Thank you for looking that up. And if anybody has any more comments or thoughts on that, appreciate it. And then maybe we can revisit if we get some more information from Bruce, if you can research it, and then from Arlene and Perry with the ASO. Any other comments or questions on this topic?
One question, Raylene, for Maya, I guess. I'm a little bit unclear on the voluntary compliance piece. Are we talking about at a diversion point? Because you could certainly require that as a sentencing matter, couldn't you?
Well, you can only require that the youth participate. You can't order that the parents participate.
No, but if it's an either or, I mean, I hate to play hardball here, and I'm not really feeling hardball, but I'm thinking if the choice is going to detention or the family joining a willing
But the kid
Defendant.
has no control over what their parents elect to do. And if their parents are using substances or have 7 other kids or are working and are like, this is not a priority, I'm not doing family functional therapy, the kid can't be punished for their parents' lack of interest or willingness to participate. That's the issue.
Okay,
But I would like to point out that there's a subtle difference between requiring participation and encouraging participation. So somewhere in between, it's possible to encourage people.
Point taken. Thank you. Well said, Arlene. I don't see any other hands on this topic. If anybody has anything else they'd like to add, please let us know before the next meeting. And we're going to move on to recommendations for amendments to state legislation on police reforms. Myself, Maya, Under Sheriff Chadwick, and Dan Hamill met on Friday and went over the legislation. I sent my notes off to Jill. Oh, sorry, I see Bruce's hand up. I'm going to let him go.
I was just going to let you know that I need to prepare for a presentation this afternoon, and so I'm going to bow out. So Jake can fill me in on what I miss. So thanks, and have a good rest of the day, everybody.
Thank you for that, Bruce. Appreciate your participation.
Raylene, you're muted.
Okay, I think we're good now. I found myself. I don't know what happened. I hit the wrong button. I'm just trying to pull up my notes, so if you can give me just a second, I will be right on board with you. And actually, if Doug wants to take it away, I sent notes and he can start, and then I can grab my copy unless you don't have them readily accessible, Doug.
I have them, I do have them in front of me. So again, as Raylene said, we met late last week and kind of went over what would be some potential recommendations to the legislature on maybe looking some of these police reform bills that came out in this last legislative session. I don't think they're, I think the larger incarceration task force as a whole has discussed a lot of these same issues and come to a lot of the same conclusions. I'll say that of all the bills and new law that we went over, I think it really came down to probably the most concerning area that there needs to be some further review and maybe some changes is when it comes to use of force and behavioral health. When law enforcement responds to a call involving somebody in behavioral health crisis, there's limitations on the use of force when it comes to taking somebody for an involuntary commitment, taking somebody into protective custody essentially, and taking them either to the hospital or another service provider so that they can receive the treatment and the services that they need. And as it's written right now, if law enforcement is on scene, and they may be on scene with mental health professionals, they may be on scene with fire or EMS professionals dealing with somebody in mental health crisis. And if once they get there, and again, there seems to be a misunderstanding. I think some of it's from the public standpoint, and quite frankly, some of it I think is from a law enforcement perspective. Some law enforcement jurisdictions interpret that those changes in the law to mean that law enforcement cannot respond to these type of calls. And the law allows for law enforcement to respond, but once they're on scene, there is a whole list of things on the duty of reasonable care that law enforcement needs to consider. And that's calling for backup, using time, distance, and shielding, pulling in other resources such as behavioral health specialists to try and, work with folks to de-escalate the situation. But farther down that list, one of the alternatives is if there's no probable cause for a crime and there's no imminent, and they've gone even farther. And again, this comes down to conversations with our legal staff, is that interpretation of imminent really comes down to it's an immediate threat. Somebody is in danger now, and we need to protect either the officer, another person on scene, or maybe even the person in mental health crisis from an imminent threat to themselves or others. So if those two situations don't exist under that duty of reasonable care, law enforcement, one of the alternatives is law enforcement should leave the scene. So again, in the past, when taking somebody into protective custody, it may not be immediate, but based on the circumstances and the level of escalation and what the family's telling you, there's a high likelihood that if we leave, things are going to escalate, and either this person's going to do harm to themselves or others. Under those circumstances with imminent threat or gravely disabled, we would take those people into protective custody. And sometimes that required a certain level of force because they didn't necessarily want to go, but in the best interest of all involved, we would take them in protective custody and transport them. So the way the law is written and the restrictions on use of force, now it's this gray area where you're seeing a lot of law enforcement agencies are just really hesitant to use force in those gray areas to take somebody in protective custody because they don't want to run afoul of the law. So there needs to be some consistency between the Involuntary Treatment Act laws and these new laws that they pertain to. They conflict with each other, and that's what's causing a lot of the hesitation. And I know in the different committees I sit on, it's caused frustration amongst legislatures that made these changes, others that are trying to move towards some kind of unarmed response to behavioral health, frustration among the mental health community themselves and their response and the safety issues that creates for them. So I think there needs to be further review and maybe some changes when it comes to that. And that also pertains to juvenile runaways, where we may find somebody and they necessarily haven't committed a crime, but because of an imminent threat or an immediate threat, and it could be inclement weather at 2 a.m, you find some juvenile runaway dressed in a t-shirt and shorts, and it's either freezing rain, wind, those kind of things. It's safe to say that if they aren't taken in protective custody, they may succumb to the elements, and that creates additional issues. So that's the biggest change. And then some of the other discussion revolved around the move from restricting law enforcement, not just use of force, but with vehicular pursuits, to having probable cause for a specific list of crimes, as opposed to reasonable suspicion for a crime. And, the articulation that goes along with that standard. And there seemed to be some misunderstanding. And I know we talked about it. Maya and I had a discussion about, it's not just a hunch or even a lower level. Reasonable suspicion is based on articulable facts and circumstances that leads you to believe that, criminal activity has either occurred or it's about to occur. So those are some of the changes that we recommended the legislature take another look at. I know both the sheriff and I have communicated that with some of our local legislators, and I believe that they heard that loud and clear, and I think there will be some further discussion on those.
Thank you, Doug. I think I echo everything you said. I just wanted to make sure that we had the point in there that we wanted to have some more clarification from legislature in regards to how they came up with the reasonable suspicion being removed. Because I believe you brought that up in the meeting, that they believed it was because of racial profiling, but it might have been a misunderstanding on the definition of reasonable suspicion. So we just wanted to know where they came up with that and why they did that. But definitely some concerns that were brought up by everybody there. And I believe Arlene has her hand up, and Eric.
Yes, when you were describing the kind of incidents that come up for the police, I started thinking about the Grace and Lead programs in which the officers and they have a certain number of people they work with where they know the cases, they know the history, they know the behavior patterns. And so their ability to de-escalate the situation is enhanced by the personal knowledge of the situation. It's very complicated to handle those incidents, very complicated. And it really should be primarily in the hands of behavioral health, but with backup from law enforcement and support and security from law enforcement. But we're not there yet, are we? We're in the process of trying to develop those programs like the alternate response team. And, but I just wanted to point out that it's so much safer when the people responding know something about the people that they're responding to.
Thank you, Arlene. Eric?
Yeah, so I just wanted to, I guess, respond to a couple things Doug said, and I think something you said as well, Raylene, and that is, I don't think we're really asking for clarification or asking for some sort of review of the law. We're asking that the legislature make some changes. And the reason why we need some changes is because within the plain meaning of the statutes that have been written, it's clear what their intent is. We don't get to look at the legislative intent once the plain meaning is clear. So it's as the law is applied, I think it's important that the law needs to change. It needs to change, and I think that's what our recommendation should be. Raylene, you asked about why you want a clarification as to why there was a move from reasonable suspicion to probable cause. And I don't know that it's worth asking the legislature that. And I'll tell you that I think I know. Well, I do know the reason why, at least reported to me by the legislators that I've spoken to. They do believe it's based on racial profiling. They want to stop that, and that's why they did it. Does it make sense? I don't think it does. I think they're hampering law enforcement's ability to, take care of some criminal activity, to investigate crimes, and that's a problem. So anyway, I just wanted to let you know that I don't think we need to ask the legislature why they moved. It's because I guess a strong contingent within the King County area believed that the racial profiling needed to stop, and this is the way they're going to do it.
Thank you, Darlene.
Eric, I just wanted to ask you, are you finding support for this law to be changed from more than just law enforcement? Are you finding community members who understand the problem?
I'm not sure about our community members and whether they understand it. I don't know that they recognize that there's any change in the law, but I do know that our legislature understands the problems. They didn't understand, some of them, I think many of them didn't understand what they were voting for when they voted for it. I was told that they ended up with some real watered down versions after a whole lot of discussion, a whole lot of, I guess, pushing of something much more severe to hamper law enforcement. And they didn't understand the ramifications of what they came up with. So yeah, our local legislators, for the most part, are very receptive to making changes. Now, whether they win the day, whether they can persuade others down in the King County area, I can't tell you that.
Thank you, Darlene and Eric. Just on a side note, we did discuss State Bill 5476, the State versus Blake decision. And I'll we unanimously believe that the cart was before the horse, and there's all kinds of issues there. But Dan Hamill brought up some concerns as well as and Maya, it's, we don't have a navigator right now from the jail, and that there's not enough mental health and regional health programs in place. So there's all kinds of issues with the concerns with that. And then the one thing that I had talked about with the 2 pre-booking requirement that's not housed in a central database. But since we had our meeting on Friday, I did get an email from Chief Tanksley that said that to get the word out from WASPIC that they are working on some type of program with sector, the warnings for a statewide system. So at least I know there's some push to make some modifications, even if it's not as much as we'd like. But I do see Stephen's hand up. So please go.
I think I have a comment and a question. Just responding to Eric, it doesn't surprise me at all that the motivation behind some of the changes in the law was to intervene in the face of racial profiling. And I think it's a terrible mistake if our suggestions for amending the law make that an either or kind of thing. Absolutely, racial profiling happens and it should be addressed. I think we probably, I'm guessing, have a little bit less of that in Whatcom County, but we're not immune from that. And so to rebalance this entirely on the discretion of law enforcement in the face of pretty compelling evidence of the existence of racial profiling is a bad mistake, I think. So I'd like, I mean, if we have some suggestions for what that rebalancing would be that continues to address the reality of racial profiling, that would be good. But just leaving it open-ended or saying go back to the way it was with no protection against that, I think is a bad idea. I'd like to ask Doug on the relationship with the ITA. I can't remember whether 1310, did it leave out the gravely disabled kind of factor? Or is it that we don't always have a designated crisis responder appearing on the scene, and therefore we don't have an official determination of imminent threat or gravely disabled?
So the 1310 doesn't specifically address gravely disabled, and that was one of the conversations. I think it was Maya said, well, maybe that should be part of it, maybe that should be part of 1310 and that whole definition of imminent threat. Again, the interpretation of imminent threat we got was essentially immediate threat. And that's for use of force. And it certainly applies in this situation. So I think trying to line 1310 when it comes to in line with the Involuntary Treatment Act will go a long way to answering those questions. So there's not uncertainty amongst law enforcement and other people on scene about when they can take somebody into protective custody. And that I think that will be a change that I think that's probably one of the biggest things that they probably heard from law enforcement and the communities. I know the mental health community and the professionals that are out in the field, it creates a lot of concern and safety concerns for them. So I think we will see change specifically towards ITAs.
Yeah, I just want to add that, from my conversations, that sounds like an easy one. That's a gimme. That, so the other conversations surrounding the legislative police reform bills are going to be more complicated, but as the one that Doug just described is just going to be an absolute gimme.
But we're still wrestling with those situations that maybe don't rise to ITA status, but we want to divert them to the Crisis Stabilization Center. Is that correct? And are there suggestions for how to facilitate that in appropriate circumstances?
I think the first step to that is changing the law. And like I said, as Eric alluded to, words matter. And making sure that they're clear in the expectations. And a lot of times we may take somebody voluntarily to the crisis stabilization facility. But if they change their mind halfway between their home, and that may be if we're driving somebody from Glacier to the crisis stabilization facility in Bellingham, and about halfway in between, they change their mind and they're no longer voluntary. Now they become involuntary, and we need to address that. So that's, the deputies don't want to be in that position, or officers don't want to be in that position, because now you've got somebody that doesn't want to go, and you don't have a crime, and you don't have an immediate threat. So what do you do with that person now? So, I mean, you can obviously turn around and take them back, but they may escalate during that time period, and now you've created another issue. So those are some of the challenges, and it may not be appropriate for a civilian or an unarmed person to transport that person for that very reason, that things between point A and point B, again, you see a lot of mood swings, people that are manic, those highs and lows can be very extreme. So what do you do during that transport of a person that you're trying to get assistance, and they were voluntary when they got in your car, and now, because we used to do that all the time. Hey, would you like to go? I can take you to the crisis stabilization center. I can take you to detox, and a lot of those conversations may or may not be happening because of the change in the law.
And just one other thing I'd like to clarify for my thinking, and this may draw Perry in. I know we were working on trying to get certification for the involuntary shorter term law enforcement hold at the Crisis Stabilization Center. Does the legislation have any, I mean, it seems like it undermines that part of the statute, and I'm wondering if that's a topic of discussion with legislators in amending the language as well.
I probably will let Perry handle that one when it comes to the facility and the involuntary status.
Right. We continue to work on the certification for Compass Health, who is the provider at this point for certification for involuntary treatment admission. Again, that's, as we talked about, but just for clarification, it's under the criminal code 10.31 as opposed to the civil code, which really ultimately means law enforcement specifically, diversion from typical charges that allow them for a 12-hour police officer hold. There is follow-up on the individual that we have access to a DCR that can do a full evaluation as required by the state within about a 3-hour period of time, I think, just to ensure that the individual doesn't need ongoing and extensive civil ITA. And so the challenges that have been is really COVID and also workforce that has given challenge to completing that certification at this point. But I even, as I drafted, we have a lease agreement with the providers that are giving services there at the Crisis Stabilization Center. And I actually even wrote into the lease agreement with Compass Health the requirement that they continue to pursue that certification for involuntary treatment admit on that 12-hour basis. So there is work going on. It's been fairly slow. I'm actually readdressing that at this point in a more formal manner to get an idea of what's our target date and what are the final steps that need to occur in order for that to be accomplished. Hope I answered the question.
I think the one part, if you have anything you could add on this, Perry, I'd appreciate it. The one part is how the language of the new legislation would affect those criminal holds or law enforcement involvement in directing people to the CRC.
Right, really challenging, I think, because there isn't, at least from my perspective, the clarity in regard to the idea. Basically, is that the individual needs, some time to just get grounded and calm down and be in a safe place as opposed to going to jail. Then, as Doug had pointed out, that it's like, okay, wait a minute. I mean, do we have, where does this lie? And admittedly, I haven't really dialed into that from looking at 1310 and saying, you know, where's the sort of clarification here and so forth. But I would say that in terms of transport, you know, part of what, you know, Doug was talking about before, that there are some challenges that occur. You know, if the individual says, yes, I would much rather go to the crisis stabilization center than I would go to jail, and then changes their mind, you know, halfway through, I'm not sure, you know, in those given situations, of course, what, you know, what would be implemented. So I'll make a note to myself that that's something that I really need to go back and highlight the language and say, well, this is the language that, you know, that would really pull that particular piece of transporting to and putting 12-hour holds on into question in regards to 1310 language.
Thank you, Perry. Stephen, I'm going to ask you, what direction do we need to go now with this? Do you want something drafted up for the steering committee to review for the task force based on our meeting? Do we need another meeting? What direction is it that we need on this area?
I haven't given a lot of thought to this, Raylene, so I'm gonna respond off the top of my head at the moment. And I would suggest the better course would be to funnel this into the steering committee for some further discussion. At a point where you think we have some pretty specific recommendations that we want to make. I guess I haven't seen your notes or a summary of what those recommendations would be. What I've heard so far sounds pretty much like what the discussion was at the task force meeting when we had Representative Shoemake and Rammel. So I'm wondering whether we need to add to that or whether the message was clear and already communicated. That's something I can't tell from the distance I'm at in these conversations. But if you have something that you want to move forward in some more official way, and that would be one of the changes, I'd suggest we run it through the steering committee and try to get that put before the whole task force. Eric,
I mean, I participated in the discussion and was also there for the presentation, and I did not think that we came up with some novel or like groundbreaking issue identification or solutions. I think it was important that the representatives heard it in the discussion last time, but you know, I don't know. I didn't think there was anything really revelatory about what we did the other day.
The other day in the task force, or the other day in your
small group meeting?
So I wasn't there for the small group meeting. I was on vacation last week, and you know, I'd like to participate in a small group meeting and develop some language that we believe would be appropriate. And I would like to present that to the steering committee and hopefully get the task force to endorse it and provide that to the legislature.
I think that would be great, Eric. Thank you. Yeah. Raylene, would that be okay with you?
I'm good with that. Doug? You're muted.
It's probably better that way, but now I'm unmuted. I wanted to, before we move on, bring something that Stephen had talked about before when it comes to reasonable suspicion. And I understand not just put it back to the way it was and give law enforcement that discretion, but keep in mind, there's already laws that speak to racial profiling and require law enforcement agents to have policies prohibiting racial profiling and bias-based policing, and we have one here at the sheriff's office. I'm sure every other agency in accordance with that law has one in Washington State. So again, when it comes to racial profiling and pretextual stops, that kind of stuff, that's already addressed in the law. So I think allowing reasonable suspicion doesn't necessarily, put all that, allow for those kind of circumstances. There's other things that speak specifically to racial profiling and bias-based policing.
But if there is already legislation that prohibits that, and but the legislature has been presented with evidence that it's still occurring, then that was wholly inadequate. And that's why they took these further steps. So that isn't convincing to me.
Well, again, I think you addressed specifically the racial profiling portion of it. And then maybe you have stronger language towards racial profiling. And Stephen even alluded to those situations may not exist in all jurisdictions. And I'm not going to, make a blanket statement that doesn't occur in Whatcom County, but I can tell you that would be few and far between, and maybe other jurisdictions have a significant issue with that. And it sounds like that's where some of the legislators in those jurisdictions were very adamant on making these changes. So again, I think you can still have reasonable suspicion and still address racial profiling and bias-based policing.
Yeah, I'd like to take a crack at it anyway.
Thank you. I appreciate everybody's involvement in this. I would ask Doug and Maya were at the meeting before and have the notes. If you guys can go over some of that with Eric and come up with some common ground to bring to the steering committee. I don't want to leave Maya out of it because I think she has some good points. I do recall some of the stuff that Doug Chadwick and Sheriff Elfo had brought up, that some of these reform laws come from other states and other areas, and Washington is pretty good. We have our issues, don't get me wrong, on different areas. I also know that we've had a lot of conversations about data integration and some of the issues with data, and so not knowing where all of that information came from definitely leads to some of the questions, and we don't want to be that state or that committee that encourages any type of racial profiling. We want to keep that in mind. So if you three would be willing to get together and hash something out, and then if Eric, you want to present it to the steering committee, as long as the three of you are in agreement, I think that works, unless I've got some other issues. And Chief Tanksley, I see your hand raised.
Yes, if it's possible, I would like to take a peek at that as well.
I just asked the small group if you could touch base with Perry someplace in there and try to integrate that that law enforcement hold, criminal hold piece, so that we continue to keep that on the table for the CRC.
Then Jill, when is the next steering committee meeting?
The next steering committee meeting is Thursday, November 4th.
Do you think that before that meeting, you guys could have something put together?
What time is that meeting? Just because I don't have it in my calendar, and if it's going to get presented, I'll want to be there.
I believe that meeting is scheduled for 11 a.m.
Okay, can make it.
I can.
Yeah, it'd be great. It would be great if you could be there, Maya.
I can't make it at 11 that day.
Well, maybe we could get together next week and try to put something together. Maya, Doug, and Donnell.
Yep.
Maya, if there's a way that we can get your input on those recommendations before the steering committee beforehand, I'd be glad to help do that. I think your voice would be.
I'll try to meet with them, whatever, gets proposed next week. I'll try to make that happen.
Great.
We'll make it happen.
Thank you all. I believe we're running short on time. Jill, do you know if we have any public out there?
Yes, we have 3 people attending today's meeting.
Okay, then real quickly, I'm just gonna go over the next 2 topics, and then we'll go to public comment, or if there's other business that needs to happen. So task force communication, I want everybody to think about this at least for the next meeting, or if we need to bring it up at the next task force meeting, is 3 to 5 public relations that we think should be coming from the Law and Justice Committee that we want to communicate to the public. And Doug earlier had mentioned that sometimes we don't always advertise the training that the law enforcement does have in mental health. In the past, we've had some new jail diversion programs with Friendship Diversion, Jail Alternatives with the Whatcom County, their pilot program. And then in the future, needs that we have is domestic violence. So those are just some off the top of my head things that could be brought up, but I would like input from the entire committee on things that we want to communicate to the public so that they know what we are doing out there is positive. Also, the topics for the year-end report to the council, kind of in the same area, what things do we think that are necessary for us to communicate for our year-end report to the council? Arlene, your hand is up, so go for it.
I think I forgot my point. I was sitting and waiting. Yeah, I forgot. I don't know.
Is there any other business?
Would any of the attendees like to speak? Please go ahead and raise your hand at this time.
Oh, I remember that.
No hands are raised.
Thank you. Arlene, if you want to go.
Yeah, I just remembered it was to Eric Ritchie. I think it's really important for you, Eric, to put down a few of the really significant changes that have come into the system that you're a part of, because it's so, these are really monumental changes. And I really think much of the public doesn't know anything about this. So there are a lot of things. It justifies what we've been doing for several years, but also for people to understand that our criminal justice system is really changing.
Right. Thank you, Arlene. Thank you, everybody, for staying as we went over a little bit, and appreciate everybody's commentary, and have a great day. Thank you.